Hello, kids. Welcome to the Fearless Floyd Show. I'm your host, Fearless Floyd. Thank you for clicking on this video and watching my channel. It's about 12:30 Central Standard Time, Friday, January 21st, 2022. And you can always reach me at TheFearlessFloydShow at yahoo.com. You can leave a comment below. You can hit that like button. You can subscribe to my channel and hit the notification bell. And as always, you can share my videos. I want to thank you for subscribing if you are a subscriber and you're going to subscribe. Hit that like button. That always helps. Helps other people know that there's this type of videos out there and it hits the algorithm. So when they're doing a search, they can find it as well as with the keywords. So again, man, I'm very grateful for everybody that I have. I'm grateful for all the emails that I get and all the support, phone calls, accolades, all that. I want to give a shout out to my big boy, A6 Grind Time, man. I appreciate that. Hit me up on your show the other night. I was at work, couldn't jump on, but I did send you my love. So thank you for that. Big Bad Wolf, give you a shout out. I'm in communications with a mutual asset, I'm going to say. So, yeah, we got that little connection working there. So, big shout out to Big Bad Wolf, James C. Lovett. If you haven't subscribed to his channel, subscribe to him. Subscribe to A6 Grind Time. A6 Grind Time. That's my boy. While I'm giving shout outs, you might as well hit up Good Line Films, Nick Alvear. That's a good one to watch. I love that guy. And of course, the ever popular conspiracy theorist, Donut from the Donut Factory. Gotta go watch that boy. He's out there. He's he's funny. But yeah, if you want to see some serious shit, go see Good Line. Go see Nick. He's got some excellent documentaries. I mean, just blow your mind documentaries. So anyway, the whole topic of this video is, of course, I showed y'all a little bit of my legal work in Fearless Floyd's bona fides or bona fides. It depends on what part of the world you're in for that pronunciation. So I was thinking, let me Google my name and see what pops up. 'Cause I know you guys haven't. So I got home from work. I still got a bunch of energy left in me, and I figured, fuck it. I'll make a video. Oh, sorry. Another thing, I need to clean up my language because some of these phone calls I'm getting, they're not concerned with it, but they're saying, Floyd, you kind of need to clean up that saltiness and you probably get some more viewers and subscribers. So I'm going to do my best to clean up my language and make this as G-rated as possible. And, that's going to be difficult for me because, I come from the streets. I really do. I'm a country boy in the city, but, I come from the streets. You know, I earned that, kids. Believe it. All right. So the topic of this video is, so Fearless Floyd litigated, right? I'm not a licensed bar attorney. I've never, ever, ever been to law school. The only college I graduated from was Alvin Community College, and I have a horticulture technology degree. Nothing to do with law. So everything with law, I taught myself. So let's let's just dive right in. And this is just a small portion of my litigation. Floyd Pleasant Northern the Forest versus the state of Texas. Appeal from probate court number 1 of Travis County. This one right here was Ready habeas corpus for emergency protection for substance abuse treatment. And I fought the county attorney, Travis County attorney on that one. He went to the Third Court of Appeals in Waco. Next one, Floyd Pleasant Tarvin, Texas Department of Criminal Justice, appeal from the 419th District Court. So that's also in Travis County, and it went to the WACO District. I believe this is one of the ones that was reversed and remanded back to trial court, but I could be wrong. Here we go. Floyd Pleasant Tarvin versus Texas Department of Criminal Justice. Brad Livingston, Executive Director, Director, Lieutenant, Correctional Officer, Assistant Warden, Regional Grievance Investigator. Me, nah, I wasn't a problem in prison. No, I didn't drive those fucking people bananas. Not me. Not Fearless Floyd. Okay. And the reason I got my name Fearless is because these are the kind of people that I was fucking with in court. And my cellies were going, Floyd, man, they're going to fucking disappear your ass. Like, okay, so what? Nobody gives a fuck about me anyway. They threw me away. They're like a piece of trash from society. Threw me away. Uh, but you know, I prevailed. I survived. I excelled in my environment. You know how you can judge the intelligence of a person? By how rapidly and well they adapt to their environment when you put them in a completely new environment. So the next one. This one's Floyd Pleasant Tarvin versus State of Texas. County Criminal Court at Law number 8, Harris County. This is on a misdemeanor DWI that I was challenging. As if you watched my other video, you'll know that I had 3 DWIs. So what I was doing is I was challenging one of those misdemeanor DWIs, and this one was the intervening DWI. So if I could have gotten this one thrown out, overturned, or whatever, it would have reduced my felony DWI to a misdemeanor. So I was attacking my primary DWI offense that I was in prison for on 2 different fronts, and this was one of them. The other one was, through the normal channels of a conviction. All right, this one is, yep. See, this is 1987. This is actually my first DWI. There's no contest to misdemeanor DWI, driving on a Tuscan, assessed punishment 30 days in jail, $100 fine. And when I was appealing it up here, this judge of this court, Jay Carahan, I'm sorry my language, I'm trying to clean it up. Guess how much my appeal bond was for this case? It's from 1987 that I was already sentenced to 30 days in jail, which I did long time ago, and $100 fine. Okay, and this is West 2011. Keep telling you guys I'm published. I'm a published litigator. You know how hard that is to do? There's attorneys who go their entire career, 30, 40, 50-year career, never get published, ever. Okay? So I've accomplished quite a bit, and I'm kind of proud of myself. So I'll give myself a pat on the back. Yeah, nobody else going to do it for me. Yeah, see, appellant's appeal filed 19 years later was dismissed. So anyway, I appealed it, and he set my appeal bond for a 19-year-old DWI. Are y'all ready? Can I get some guesses out there? Just guess. Just throw out a number. Any number. Just Fearless Floyd, 20,000, 50,000, 100,000, 150,000, 200,000, 250,000, a half a million, three-quarters of a million, a million? Seriously? A million. $1 million, folks. For a 19-year-old DWI, and I already did all the time on, fine, all that shit. Yeah. Mm-hmm. I'm a $1 million man. Uh, for misdemeanor DWI. I drove these fucking people crazy every which way I could. Okay. But now that I'm knowledgeable and more educated and very well trained, and I'm also very clever, now I know how to go at them outside their sandbox. So while they're playing a little square, I'm walking around it stealthily, stalking them. And when I'm ready to pounce, I'm going to get my prey. So I don't play with them no more in their sandboxes. I'm going to play with them the right way. And I'm going to teach you guys that tomorrow. All right, next case. Henry Floyd Pleasant Tarvin the fourth appeal. This is in the first district, which is here in Houston. Appeal from the 269th. This is when I believe I was suing the Harris County District Clerk Charles Baccaris and Teresa Chang, and I'm going after your bonds. Coming after you, Charlie and Teresa, because you didn't do your fucking job. Oop, did it again. Britney Spears. Next one, Tarvin versus State. No contest, amended for CWI. That was a, that's my, no, that's my second one. That's my first one. Okay. This one, Tarvin versus State, an inmate representing himself, pro se, filed a petition for writ of habeas corpus in the probate court seeking emergency protective custody for treatment and rehabilitation for chemical dependency. I told you, kids. This is under Texas Health and Safety Act, section, can't remember. But I can tell you this, that on September 1st, 2009, they amended it. And I actually fell under what's called the old law, which was from August 31st, 2009 prior, because it's the date of the offense of your commission date and is when the law in effect is jurisdictional over you or over your case or whatever matter you're trying to address. And the county attorney, which we went up, I was in that case up there. He completely lied and cited the new law that changed, and Texas changed the way they wanted to treat substance abuse and all that shit. Um, but the only way you can get chemical dependency or substance abuse treatment in prison is if the parole board grants you parole and puts you in a program. So if you sit there for 20 years, almost slipped up again, 20 years, okay, and you're in there for your 19th DWI and you got 6 methamphetamine convictions, you're going to sit there for 20 years. And the best you can do is AA. They're not going to put you through any treatment program until you make parole. That is how screwed up the system is. I'm not saying it's an ideal system. At least now they do give you some kind of treatment, and it worked for me. Don't ask me how. That's a whole nother story, whole nother video. Here you go. Floyd Tarvin versus Charles Baccaris. Civil case. There's fucking Teresa. Lauren Jackson. Oh, I forgot about that clown. I'm gonna go get your bond too. Uh, Tarvin versus Thaler, that's the director. Writ of habeas corpus under 2254. He challenges a 2002 conviction in the 351st District Court of Harris County. So this would be my federal post-conviction writ of habeas corpus pursuant to Title 28, Section 2254. And if you have a federal conviction, it'd be 2255. Tarvin versus State. This is my misdemeanor. Again, same shit. Tarvin appeals, first court of appeals. Yeah, there's my misdemeanor again. Tarvin versus Texas Department of Criminal Justice. Of course, judgment dismissing as frivolous his lawsuits against appellees Brad Livingston, Rick Thaler. Yeah, that's that one again. Tarvin versus Criminal Justice, notice of appeal, dismissal, suit for WANA prosecution, which was apparently signed. The court's refusal to grant its motion to reinstate. I believe this is the one that got reversed and remanded. One of them, anyway. Relator Floyd Pleasant Tarvin IV filed pro se application for petition for writ of procedendo pursuant to Texas Rule of Appellate Procedure 72. See, kids, I'm telling you, I filed everything. Okay? There's nothing I haven't done in the legal world. Okay? Relator asked the court to direct respondent one to rule on his application for writ of coram vobis, not to be confused with a writ of coram nobis, pertaining to relator's underlying civil suit. I could click on these and go through these, but you're more than welcome to look this shit up and do it yourself. I already know. I lived it, so I don't need to relive it. I'm just sharing it with you guys. So, Floyd Pleasant Tarvin versus State. Writ of habeas corpus has that emergency protection. And all these guys are clowns. Frickin' court jester clowns. I mean, hey, I'm calling you out, guys. Yeah, you don't deserve to be on the bench. You don't deserve to be elected by the populace. You don't even deserve to have your name in print on the internet. That's how sorry you people are. You can't read. You can't follow the law. You pitiful, sad waste of human flesh. That's what I think about you guys. You have no redemption, no values, no integrity, no courage, no honor, no good faith. You're just trash. Y'all think I was trash. You're garbage. Per curiam, okay? Whenever you see per curiam, they're hiding. Anonymous, that's what it should say. Per anonymous. We don't want to say who we are. Uh, we don't want you going after our bonds. Notice of appeal on this court complaining district court's dismissal of a suit for warrant of prosecution, which is apparent. Okay, yeah, that's just a repeat. One prosecution. We reversed the trial court's overruling of Tarvin's. We reversed the trial court's overruling of Tarvin's, whatever I filed, because they erred in failing to hold an oral hearing on Tarvin's motion to reinstate. Reversed, remanded, published in the books. Absolutely. Y'all better recognize. Same thing. Officials at TDCJ Inmate Trust Fund shall deduct funds from the inmate account of Floyd Pleasant Tarvin, TDC, there's my warehouse receipt number, and forward them to the clerk of the court on a regular basis in compliance with provisions of Title 28, Section 1915B, until the entire filing fee of $400 has been paid. Yeah. Meanwhile, while y'all are robbing my frickin' trust fund because y'all made me a trustee, yeah, I got all these bonds out there under that number. Blah, blah, blah. I can't even say it. Currently in custody of TDCJ pursuant to, yeah, no, it wasn't pursuant to that's my misdemeanor. Oh, and the 22 judgment sentence. Yeah. This was U.S. versus the United States District Court. Yeah, y'all are reading that right. Tarvin versus the United States District Court, Southern District of Texas, Houston Division. Oh, yeah, folks, I sued the court. A federal court. Yeah, these people know my name. They don't know my face. They know my name. They know who Floyd Pleasant Tarvin IV is. Let's see. There's that probate. Yeah. Procedendo. There it is again. This is another one that I sued. I don't even know what this one is. Let's just click on it for fucking. Oops, sorry. Click on this for giggles. Oh, there's a 351. We've already seen that one. On two. This is my DWI misdemeanor. Ex parte Floyd Tarvin writ. Okay, it's one of my writ of habeas corpuses. Let's see what this has to say. Hmm. Okay. Haha. Yeah. Let me read this. Okay. Because this is my state post conviction writ of habeas corpus pursuant to Texas Code of Criminal Procedure Article 11.07. And ex parte means I'm going in, I don't have an opponent yet. This is the writ number. This is assigned by the Court of Criminal Appeals. This means this will stay static. The 17817, this will stay with you all your life under this name in this court. And all they do is just however many you file, the next one will be 11, the next one will be 12. So, okay. And this is the order, and you can see again, it's anonymous. Pursuant to the provisions of Article 1107 of the Texas Code of Criminal Procedure, the clerk of the trial court transmitted to this court this application for writ of habeas corpus. Yeah, I only filed it in 2005. Yeah. So, applicant was convicted of driving while intoxicated and sentenced to 60 years imprisonment. Yeah, 60. You read that right there. 60. The first court of appeals affirmed his conviction. Tarvin versus State. Applicant contends, among other things, that his trial counsel rendered ineffective assistance of counsel. Hey, JT Wilhite, how you doing there, bro? Mr. Disbarred attorney. Uh-huh. On September 18th, 2006, the trial court signed an order designating issues, but no findings of facts and conclusions of law were forwarded to this court. We believe that this application was prematurely forwarded to the court. Applicant has alleged facts that, if true, might entitle him to relief. Strickland versus Washington, which is the standard of review for ineffective assistance of counsel. It is a Supreme Court case, and it is adopted by the state of Texas in Ex parte Limke. In these circumstances, additional facts are needed. As we held in Ex parte Rodriguez, the trial court is the appropriate forum for findings of fact. The trial court shall provide applicant's trial counsel with the opportunity to respond to applicant's claims of ineffective assistance of counsel. The trial court may use any means set out in the Texas Code of Criminal Procedure, Article 11.07, Section 3D. In the appropriate case, the trial court may rely on its personal recollection, id, which means back to here. If the trial court elects to hold a hearing, it shall determine whether applicant is indigent. If applicant is indigent and wishes to be represented by counsel, the trial court shall appoint an attorney to represent him at the hearing. Code of Criminal Procedure, Article 2604. The trial court shall make findings of fact as to whether the performance of trial counsel was deficient, and, if so, whether counsel's deficient performance prejudiced applicant. Okay? This right here, okay, not the finding of fact, whether the performance of trial counsel was deficient, and if it was, whether counsel's deficient performance prejudiced applicant in any way. Okay, and in Texas, trials are bifurcated, which means you have a guilt and innocence phase, and then you have the punishment phase, bifurcated, two parts. Okay, and this is the standard of review under Strickland versus Washington. Okay, I'll learn you. The trial court shall also make any other findings of fact, conclusions of law that it deems relevant and appropriate to the disposition of applicants' claims for habeas corpus relief. This application will be held in abeyance until the trial court has resolved the fact issues. The issues shall be resolved within 90 days of this order. If any continuances are granted, a copy of the order granting the continuance shall be sent to this court. A supplemental transcript containing all affidavits and interrogatories, or the transcription of the court reporter's notes from any hearing or deposition, along with the trial court's supplemental findings of fact and conclusions of law, shall be returned to this court within 120 days of the date of this order. Any extensions of time shall be obtained from this court. Boom. Absolutely. And this order went to my trial court judge, Mark Kent Ellis, who during my trial, because he didn't sit at the bench in my trial, was over trying the South Park Mexican, the rapper from South Houston. Y'all remember him? And gave him 45 years for raping his girlfriend because, she was like 12. That's just part of the Hispanic Latino culture, marrying when they're young. So here's the order, okay? And you can see the date, August 19th. So you go 90 days up, and you're roughly September, October, November. So you're right around November 19th. Okay. We'll just round it off November 20th, make it easy. There's the 90 days. Okay. Right there. 90 days of this order. Well, guess where Fearless Floyd was 90 days on November 20th? My ass was still on the wing unit, waiting to be bench warranted back for my hearing. Well, of course, I bombarded the trial court with all kind of motions. I was ready. I was prepared because by 2009, I already had 7 years under my belt of litigating, 7 years of studying DWIs, horizontal gaze nystagmus tests, standardized field sobriety tests. Oh, yeah. Fearless was packed, loaded, cocked, and ready to shoot. I was ready to go to a gunfight. So I waited for 120 days. Okay. Right here. Well, guess who didn't benchmark me back for the hearing? Marquette Ellis. And I hate to kind of pound on this, but I'm just trying to give you guys an idea of some of the battles and some of the wars that I personally faced and what I've gone through and how it made me get to this point today. So when I tell you something, when I explain something, when I show you something, I'm not full of shit. All these guys on YouTube and and Facebook and all these other platforms who sit there, I did the prove it. Show us the proof. What you got? Show me your self litigation. Show me what you did. Okay. So they have this thing called equitable tolling on the federal level. And when you're in after your conviction is a final conviction, which means that you've exhausted your appeals, and your appeals can be your direct appeal to one of the 14 courts of appeals. Mine was in the first court of appeals. Okay. Then you do a petition for discretionary review of the Court of Appeals memorandum of opinion to the Court of Criminal Appeals. Now they can refuse it, they can deny it, they can dismiss it. Mine, they refused, I believe. I believe it's up there somewhere. They refused it. So then you want to go straight to the U.S. Supreme Court because you want to stop that equitable tolling. And equitable tolling is you have 365 days. And every day you're not in court after the date that your conviction is final, that 365 goes 364, 363, 362, 361, and that's called equitable tolling. And we can all thank William Jefferson Clinton for signing that bill, the ADEPA, Anti-Effective Terrorist Death Penalty Act. I can't make this shit up. Okay. Yeah. Bitch signed that into law. So for the really ignorant, unintelligent, or people who, they just fucking get kangarooed, they lose that 1 year equitable tolling. And then once they exhaust their state post conviction remedies, which is the 1107, which you're seeing here, they can't file a 2254 in federal court because their equitable tolling got used up. Thank you, Billy Clinton. Thank you. Appreciate you. That dude's dirty. Word go. So, anyway, I'm doing a pretty good job cleaning up my language, aren't I? I think I'm giving me a little pat on the back for that. So, the 120 days comes up. I've already filed all these motions into the court, and I'm, ready to go back, man. I'm Mr. Eager Beaver. And I'm disappointed. I'm getting like really messed up. So, pursuant to 11 Code of Criminal Procedure, Article 1154, I want to say. Y'all thought Fearless was playing around. I ain't playing around, Mama. I'm serious over here. I want my candy. I'm gonna get my candy. I was close. I highlight it like I always do. Like you should too. It is actually Article 11.61 of the Texas Code of Criminal Procedure. So let me read you what 1161 says. Anyone, even a sitting, presiding, elected judge, anyone having another in his custody or under his power, control, or restraint, who refuses to obey a writ of habeas corpus, or who evades the service of the same, or places the person illegally detained under the control of another, removes him, or in any other manner attempts to evade the operation of the writ, shall be dealt with as provided in Article 11.34 of this code. Well, Fearless, what the hell does that say? Excuse me, hell's not a bad word. Here we go. This is a little lengthy. Article 11.34. Disobeying writ. When service has been made upon a person charged with the illegal custody of another, that would be this order that you see right there. Let me reread that. When service has been made upon a person charged with the illegal custody of another, if he refuses to, let me back this up. When service has been made upon Judge Mark Kent Ellis, charged with the illegal custody of Floyd Tarvin IV, if Mark refuses to obey the writ and make the return required by law, or if Mark refuses to receive the writ or conceals himself the court or judge issuing the writ, Court of Criminal Appeals, shall issue a warrant directed to any officer or other suitable person willing to execute the same, commanding him to arrest Mark Kent Ellis, charged with the illegal custody or detention of another, and bring Floyd Pleasant Tarvin, or no, bring Mark before such court or judge. When such person, when Mark has been arrested and brought before the Court of Criminal Appeals, if Mark still refuses to return the writ or does not produce Floyd Pleasant Tarvin in his custody, he shall be committed to jail and remain there until he is willing to obey the writ habeas corpus and until he pays all costs of the proceeding. That's the law. And what do we know that these people, these elected officials that you guys put in office, because I didn't vote for any of them, they don't follow their own laws. So when I wrote that and put it in a petition, not a motion, I got a letter back from the staff counsel of the Court of Criminal Appeals, not the court itself, not a per curiam anonymous order. Their staff attorney dismissed my case. Didn't deny it, dismissed it. There's a difference. Yeah, an all Republican court, a Republican presiding judge in my convicting court. It probably wouldn't be politically correct to issue a capias for his arrest, i.e., warrant, and have him transferred from Harris County to Travis County to be brought before the court to answer why he was disobeying the writ of habeas corpus and not bringing the body. That's because that's what a writ of habeas corpus is. Bring me the body. How come he wasn't having me back in court pursuant to this order? So we could find facts and conclude law why J.T. Wilhite, my trial attorney, was ineffective. Okay? And God knows I wanted to get back in court. So I wanted to put my attorney, J.T. Wilhite, on the stand under voir dire, under oath, and roast him like a marshmallow over an open fire on a chilly night. Oh yeah, I did. Okay, so enough of this. You guys have seen this, heard the story, so now you know what's up. Okay, comes to legal work. Fearless is a bad motherfucker. Oops, sorry. Yes. Okay, so we went into that one. See if we can stay on track. What's this one? This one is a Court of Appeals, First District. This is writ of mandamus. Okay, let me tell you a little bit about these writ of mandamuses. I filed a couple dozen of them, maybe. These tricks, these guys in this court, tricks, garbage, elected garbage. I'm gonna go get your bonds too. And you guys in the 14th Court of Appeals, I'm coming for you too. Yeah, just give me a minute, okay? Filed a pro se application for petition writ of procedendo pursuant to Technical Procedure 72. This is actually the memorandum opinion. Let's see who signed a per curiam. Yeah, we're gonna hide. But the panel consists of Justice Keys, Bland, and Sharp. Bland, trash. Sharp, trash. Okay. So what they're telling you is this is the panel, which is three judges. Okay. But they're not going to say which one wrote the opinion. And in reality, none of these three wrote this opinion. You know who wrote this opinion? A law clerk. Absolutely. And they just rubber stamp it. Okay, there's that one again. I don't even know what this one. Let's just click on it and see what it's about. More prosecution. That's in the WACO. Versus Court of Appeals. These seem to be about this one. This is where I'm suing the district court. So let's just go peek at this one real quick. Y'all thought I was kidding, huh? No, this is about 2254. Dismissed with prejudice because the claims are frivolous and because plaintiff is barred from filing complaint without paying the fee in advance. They're going to deduct funds from my inmate trust fund. And yeah, they did this because I was. They labeled me a vexatious litigant. Yeah. Old Judge Keeling out of Walker County, Texas. The late, not great Judge Keeling. That piece of crap. Wouldn't even unhandcuff me. Have you ever seen the movie Con Air? You know how they got them all shackled up, got the ankle chains on, the wrists are like this, and they can't turn them, but they're even chained to a leather belt going around them. Yeah, that's how I was in court, trying to litigate against an assistant attorney general in a free world outside attorney they hired because they weren't qualified or educated enough to go against me. So they hired outside counsel. Absolutely. And we're in the grand jury room in Walker County, Texas, in the courthouse, county courthouse. And there's, they're in there doing plea bargains in the regular court with a visiting judge. And the sitting presiding judge is in here conducting my hearing, won't unhandcuff me. I got a bag full of freaking legal work. It's all bound, kind of looks like that spiral thing. you know, and I'm arguing with him. Oh, Texas is the judiciary courts of the state of Texas are for-profit corporations. Oh no, it's not. It's a republic, man. I've got the Dun and Bradstreet background report. It's proven it's a for-profit corporation. No, it's a republic. So I'm digging through a homemade bound book that's about this thick. Okay, looking for this three pages. I'm looking for these 3 pages right there. DMB, business background report. What's that say? Judiciary Courts of the State of Texas. Oh, established in the year 1845 by the people, employees. Oh my God, what's that say? Date incorporated, 1836. State incorporate Texas. Oh, Thomas Williams, he's the Chief Justice. That's the big guy. What's that say? What's that say? What does that say? Oh my God, Fearless Floyd. You were right. Judge Keeling was wrong. Of course I was right. Hey, Judge, I hope you rot in your grave, bro. That's what you get for being a ding dong. Fearless won. You lost. Okay, what's on? 068. Trials and tribulations, kids. This one is 178. Yeah, this is my conviction for possession of a controlled substance, selling a quarter-pound rock or cocaine to Bob Romano, Houston Police Department undercover narcotics detective. Yeah, I did that. But that's what happens, man, when you like trust your friends and your friends get popped, they don't tell you, and they want to work off their cases and set other people up, and I'm a victim. Habeas corpus relief granted. Yeah, John Holmes, that was the DA back then. No, this is old. Judge Harmon from the 178th. Wow, I didn't even know this was around, to be honest with you. And you can see it's from 1988, June 6, 1988. Old Bob Romano. Yeah. Let's see. Baccaris, Charles Baccaris, Mark Kent Ellis, General Counsel to the Texas Court of Criminal Appeals, Judge Sharon Keller, Jack Rohde, who was an assistant district attorney for Harris County, Texas, who is now the district attorney for Galveston County, Texas. That's who Jack Rohde is. Oh, yeah, I sued him. Mm-hmm. Y'all think Floyd's bullshitting. I'm telling you guys, I've been there, did it, done it. Next! Let's see, 2008, Jennings, Hanks, county criminal law. Okay, yeah, this is that misdemeanor I challenged. Let's see what this says. See, whose website is it? Houston Opinions, right here. Hey, you guys, these are not judges. They are justices in the courts of appeals. Shit, so you know. That's why it says justice, not judges. Okay, what am I looking for? I don't even know what I'm looking for. I'm just looking. Oh, about the writ of mandamus, I will tell you that. When you file a writ of mandamus in a court of appeals, they turn it into a motion. That's not what a mandamus is. That's not how it's lawfully defined or legally defined. But that's how corrupt they are. Okay. I'm not going to sit here and dig for this crap. I lived it. I already know what it is. I'm just like whizzing y'all through this here. There's a 72 again. Tarvin State. Yeah, I've been through that. This is a federal case. Tarvin versus U.S. District Court. All I got to do is look at the case numbers and I already know. I can tell you exactly what it is. Oh, and here's a little cherry on top because, you know, let me, before I get to this right here, let's see, see what we got. See if we can find it. Probably have to go to their website. This looks like it's popping up all the same stuff. Oh, here it is, right here. Tarvin versus Stevens. William Stevens, the director of the Texas Department of Criminal Justice Correctional Institution Division. Right there. I'm in volume 136, Supreme Court Reporter, page 205 from 2015. There's my lawyer's edition citing. Okay. I tell you guys, I've been to the United States Supreme Court over a dozen times. Petition for writ of certiorari to the United States Supreme Court. Oh, to the United States Court of Appeals for the Fifth Circuit. Denied. Did I not tell you I've been to all these courts and back? Telling you folks. Here, let's stop share just to make sure it's shared. We want to share sharing. Here it is, Tarvin versus Stevens. There's the site, 136 Supreme Court 205. I think this is one of two or three that I'm published in the United States Supreme Court Reporter. And then the Fifth Circuit U.S. Court of Appeals in New Orleans on Metairie Street. Trying to remember the numbers, the actual physical numbers to the address, but I can't. I used to know every address for the court by heart because I freaking typed them a gazillion freaking times. So now here comes the cherry on top, just to help you guys out. Where's it at? Oh, here's my videos. Okay, let's go back up here. Here we go. Floyd, Pleasant Floyd Tarvin, married to Patience Vivero, children, Beauregard, B.C. Tarvin. That would be my great uncle. Sehoy, McGilvery, Tarvin. Want y'all remember that? Sehoy, McGilvery, Tarvin. Richard, Alicia Tarvin. Uh, Grandson of Marion Alicia Tarvin, which was a doctor who's actually a dentist. Okay, so we're just going to click on that. Oh, click allow if you're a robot. What the hell is that? Let me see allow to you. Oh, that's weird. Hmm. Notification block. Oh, okay, let me, here we go. See if this works. Payments web. What? DuckDuckGo with this bullshit. Sometimes I hate DuckDuckGo. Gets in the way. Okay. So anyway, stop share. I'm gonna do it this way. Here's Sehoy McGilvray Marshall of the Wind Clan. Okay. She is the daughter of Captain Jean-Baptiste Louis de Cortel Marchand and Sihoy Cushata of the Alabama Cushata Indians. I'm sure you heard of them right here in Livingston because they're cousins of the Seminoles and the Creeks. Okay, so she had a son, Alexander. Okay, so let's find out who Alexander is. Open him up. Alexander Goodchild King, principal chief of the Upper Creek Muskogee, Coshada Village. Okay. See his name, Weatherford? That would be William Weatherford, Chief Red Cloud. Okay. So this is my sixth grade uncle, Alexander McGilvery. So that's him right there. He was a leader of the Creek Indians during and after the American Revolution who worked to establish a Creek national identity and centralized leadership as a means of resisting European American expansion onto Creek territory. This tells you the same thing. A loyalist like his father, McGilvray resented much of American Indian policy. However, he did not wish to leave the United States. McGilvray became a leading spokesman for all the tribes along the Florida-Georgia border areas. Georgia's Yazoo land scandal convinced George Washington, that would be the first president, General George Washington, that the federal government needed to control Indian affairs, and in 1790 he sent a special emissary who convinced McGilvery to attend a conference with Secretary of War Henry Knox in New York City, then the capital of the United States. The conference resulted in the Treaty of New York. Uh-huh. Yeah, he was that guy who signed the treaty with the United States for all those Indians. Yeah, my sixth grade uncle, who comes from Indian royalty, chiefs and princesses. Absolutely. So just a little bit more of my bona fides. Y'all can read this for yourself. Okay. This isn't hard to find. William Weatherford. And that's right there, Chief Red Cloud. Goes on and on, talks about, more and more and more. There's no relative, Colonel Tate. Seminole Nations. Just to give you a little bit. Well, he's buried with Masonic honors. Oh, God, don't let me find out. That's funny. Uh, yeah, goes on and on and on and on and on. Yeah, he was there it is, 1790, Treaty of New York. And he was appointed the rank of general by General George Washington. Well, actually, he was president then. So, yeah. That's my sixth grade uncle. That's cherry on top. But anyway, this whole video is just, I hope I'm not even screen sharing. Oh my God, I'm just like talking to a blank screen. Here we go. Sorry. Internet. Here's the link. It's on genie.com. Alexander McGilvray. Y'all can look it up. Okay, there's Seahoy Third Weatherford from, that I was telling you all about. Shot a village. That's where, talks about him. Yeah, that's me. Fearless Floyd's the real deal. Oh, I can't wait to play with y'all tomorrow and do the official bond, official oath. Y'all gonna love it. As always, you can reach me at the Fearless Floyd Show at yahoo.com. Yahoo! If you stuck around this long in this video, God bless you. I appreciate it. Like the video if you do, share it, hit that notification bell if you want to know about all my videos that I'm putting online. I hope you really appreciate me just doing this outpouring of who I am, what I've been through, so y'all can look on my back as well and see those tire tracks all across my back, baby. I can see you had your fun. Darling, can't you see my signals turn from green to red? With you, I see a traffic jam straight up ahead. You're just like cross that traffic. So hard to get next to you. Cross that. I want to run over you. There's a little Jimmy for you. You like that? I just had to throw some entertainment in there at the end. So y'all leave a comment below. And I promise I'll try to clean up my language next time and make it just like a G-rated for all the kids out there and all the other people who feel offended by my salty tongue. And again, kids, thank you very much, man. From the bottom of my heart. Now you know a little bit more about me. You can Google me. You can look me up. You can read my cases. You can actually go to those court clerks and you can pull up the record and look at them. It would be a lot easier to go to the appellate court because the record's much cheaper. It's probably 10 cents a page versus $1 a page at the appellate court clerk and the district court clerk, respectively. I have to get that order in my mind. So, with that, again, thank you very much. Appreciate you watching the video. Hope you learned something. And guess what? Tomorrow, be ready because we're going to hit the books, kids. We're going to go through some really good stuff. Okay. Not only am I going to show you what's going on, what is that, Fearless? Public official bond? You have somebody's public official bond? Traveler's insurance under Roto. I hope you look forward to that one, kids. I'm going to educate you. And we're going to go out there and we're going to conquer the world. Me, you, and Dupree.